Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you are going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Erin.
Good morning, David. How's your morning going so far?
It's wonderful.
Wonderful? Good to hear.
Yes, it is.
Okay, so, for the next few weeks, we're going to be talking about wills and will contests. So what does it mean to contest a will?
Essentially, it's a challenge of the document. So if you're an interested party in the person's estate and they pass and someone submits a will to the court, asking the court to determine to be the will, and you look at it and you have a factual basis for coming to the conclusion that this was not executed by the decedent by their own free will. That can include a lot of things. I mean, that has subparts to it. So one is the free will part. Well, maybe you know that this is not the decedent's intent of their free will, so maybe someone pushed them into it. Or maybe it's a forgery. Maybe you recognize the decedent's signature and you look at it and it's clearly, you look at it and say, well, okay, this gives everything to Sally Jane, and oh, those are two of Sally Jane's best friends as witnesses, or Sally Jane's children, and that's not mom's signature. So you contest the will on that basis. There are different grounds that we'll discuss later, I suppose, on how a will is contested. But essentially what it is you filing some sort of formal objection through an attorney. So it doesn't help to just show up to the court and say, well, this will is bogus. And as for continuance, they show up again and say, this will is, I've seen this. This will is terrible. I know it's not true. And then the court admonishes the person, says, well, you need to hire an attorney and file a contest. And they keep showing up until at one point the court says, well, I've admonished you several times to file a contest, and you keep showing up, and you have your briefcase full of documents, loose documents, and you keep saying all the reasons why it's bogus. But you're going to have until next hearing, otherwise your objections are waived. And I've seen people not show up, or show up and objections are waived and the will is admitted. So to contest a will is to challenge its validity, and to do it formally through the court process. Writing letters to the court, writing letters to the proponent of the will, showing up, voicing your objections is not sufficient. You need to file an actual contest of the will. It's a formal document. And you need to prosecute your contest, meaning that you're going to participate in the court process until you get to a hearing in which evidence is taken. You present your evidence, and evidence as described by the court and the laws, not evidence as to what you subjectively feel is your own personal recollection, which should be evidence. So it's a formal process, and it requires evidence for the court to take the conflicting presentations of the case and make a determination as to who is right and who is wrong, and more specifically, who has met their burden of proof, who has met their burden by demonstrating that they are right. And that is a will contest.
Okay, thank you very much.
You're welcome.
And if you guys have any additional questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.